I'm going to introduce our panelists, and then because we couldn't manage, even though all of the magic that takes place in Las Vegas, we couldn't manage to get Mary Beth Tinker here, but I did sit down and do an interview with her a couple of weeks ago, and we will show a little video of that for a couple of minutes. Our panel includes, to the my far right is James Hanks, who is of counsel at Ahlers Cooney, a Des Moines firm, which coincidentally for today's topic, or maybe deliberately for today's topic, represents the Des Moines School District. Jim is a education lawyer as well as a labor and employment lawyer, and his firm represents 150 different school boards and school districts, and he has had a career of counseling school boards, school districts on education law issues. We're delighted to have him here. Next to Jim is Alex Johnson, who's not foremost credit, but the one that matters most to me is that he's my former student. But besides that, he is the program director at the California Wellness Foundation and the president of the Los Angeles County School Board, and has been very active for many years in education law and policy issues. Next to me is Sam Russo, who's an assistant professor at California State University, Dominguez Hills. He teaches political science courses in constitutional rights, civil liberties, and other things. He practiced law for a number of years before deciding to head off to earn his PhD and move into political science teaching. And sadly, we lost our fourth panelist, Kay Kindred, who was under the weather, and so won't be with us. I think with that, why don't we show the video and then we'll come back and talk a little bit about the Tinker case. We'll get into some questions with the panel, and then we'll have lots of time for questions and discussion with you.
In 1965, it was a time a lot like now, which students have described as mighty times, and I agree. It was mighty times, and we have mighty times again today. By 1965, at Christmas time, the U.S. Congress had voted almost unanimously to start escalating the Vietnam after the Gulf of Tonkin incident. And so by then, we were seeing on the news these horrendous images of bombing of houses on fire, huts on fire, children running from their burning huts, all of those famous images.
And so the protest itself in December 65 then was aimed at the Vietnam War.
Yes, the first national protest against the war happened that Christmas, well, that November of 1965 in Washington, D.C. And my mother went along with my brother John, and also Chris Eckhart, who later became one of the plaintiffs, and his mother were there. And on the way home, they were talking about what could be done in Des Moines to speak up about the war. And the idea of black armbands was raised, we think, by a man named Herbert Hoover, who was a Quaker and a distant relative of President Herbert Hoover, who said, what about black armbands? After the children were murdered by the Ku Klux Klan in 1963 in Birmingham, James Baldwin put out a letter calling for everyone to wear black armbands and to have memorial services around the country. And so in Des Moines, there was a memorial service, and some in our family attended. I don't think I attended, but we do have photos from that with Chris Eckhart's father speaking and wearing a black armband. So the idea of the black armbands had been around, and of course it goes way back in history as a symbol of mourning.
So you and your brother and Chris Eckhart decided to wear black armbands to school, and even though the principals met and said you would be suspended if you wore the black armbands to school, you were 13 years old?
I was 13 years old in 8th grade at Harding Middle School, and I'm really excited to be going back there in February on the very day of the ruling to celebrate the 50th anniversary of the ruling. But there was a small group of students, mostly high school students at Roosevelt High School, who made the plan to wear black armbands to mourn the dead in Vietnam, and number two, to support a Christmas truce that was being called for by Senator Robert Kennedy. That was our message.
It must have taken a certain amount of courage to do this knowing that you were going to be suspended. I mean, by the time you went to school that next day wearing the armband, the principals had announced that you would be suspended if you wore the armband.
Well, as I like to tell students, it took a little bit of courage. And that's how much I had. I was a very, very shy girl, one of the youngest in the family. And I had these examples of other kids who had spoken up and stood up. And then I had my parents' example. And so I like to tell kids, it only takes a little bit of courage. And you can find that and do something. You may be surprised at how much of an effect you can have, even with your little bit of courage. Because when I got to school and was sent to the office and told to take off my armband, I looked around the office and I looked at Mr. Willitson and I said, okay, and I took off that armband. After we wore the black armbands to school and got suspended, my brother got suspended the next day. 5 students got suspended. And then people started sending us hate mail. We got a lady called me on the phone and said, is this Mary Beth? And I said, yes. And she said, I'm going to kill you. And I was so surprised and perplexed by all of that. People threw red paint at our house. They threatened to bomb our house on Christmas Eve. It was really shocking and surprising to me in a way because we were speaking up for peace at Christmas time. And, you know, as a kid, I thought that's what you're supposed to do. That's what we've been...
Supposed to fit with the holiday. So let's fast forward the 3 years to February 1969, and you learn about the Supreme Court ruling in your favor. What did that mean to you? How did you learn about it, and what did you understand about it?
When I learned about the victory at the Supreme Court, I was a junior in high school, and by this time we had moved to St. Louis, which was a big city to me, and I was just getting used to my new school. We had moved there in November, right before the oral arguments, and I was very shy, so I was really preoccupied with kind of adolescent issues. Who am I going to speak to in class, and what am I going to do for lunch, and things like that. So I was really surprised, though, when we won the case, because we had lost at the district level, we lost at the appeals level. And, you know, I thought no big important Supreme Court judge is going to say kids have rights, or that we were right to break the rule in school and wear our black armbands to school. So I was really surprised. But as I've gotten to know First Amendment experts and lawyers through the years, I've realized that because of the climate and who was on the court, it really wasn't a big surprise to a lot of people. Like our lawyer, for example. We had a wonderful lawyer named Dan Johnston with the ACLU. Thinking back on it, I've been kind of surprised that the social studies teacher or the English, somebody didn't say, hey, everybody, something kind of interesting happened to Mary Beth yesterday. It was really a teaching moment, but...
And that didn't happen?
Not that I remember, but I think a lot of teachers and administrators were also thrown off guard a little bit, and they didn't know how to respond exactly, because it really shook up the power dynamics. I remember Time Magazine they came to my chemistry class, and it was really, I mean, I was mostly just embarrassed and wanted to sort of hide, but I felt that way for some years, actually. I was really shy, and I didn't know what to do, how to deal with all of this. But later, I went to work as a nurse. I became a nurse and a nurse practitioner, and I worked mostly with kids and teenagers, and I started to see how they do not get a fair deal in our society, and they're not the highest priority. And so I thought maybe I could tell them some of my experience and encourage them to stand up and speak up for themselves also. You know, so slowly over the years, I realized the importance of the case and how it's still important today. And yes, it's been chipped away at and it's been weakened by the 3 Supreme Court cases, especially on free speech for students that came after it, Frazier, Hazelwood, and the infamous Bong Hits for Jesus case. But basically, the meaning of the ruling remains that students do have free speech rights in school, and that their humanity and their views and their input should be respected.
And let's talk about what you think is the current state of student rights in schools.
It's very heartening to see how students are speaking up and standing up for their own interests. And of course, that's always been the importance of the First Amendment. Groups that did not get a fair deal or that were left out of our democracy needed the First Amendment to speak up and say, wait a minute, we should be included as well. And I think that's what young people are doing now. When you look at Black Lives Matter or the March for Our Lives, the students in Florida, I mean, every 3 hours on average, a young person is killed by gunfire in the United States. And I've been a trauma nurse with teenagers. The ones that survive would be my patients. So I am very heartened to see how young people are speaking up and standing up for themselves. They are the most likely age group to live in poverty. They're affected by housing policy, climate policy. I mean, we've got now, I think 10,000 kids in Flint, Michigan were poisoned by lead in the water because of policies made that the kids themselves, the young people themselves, had absolutely no say in.
And are you seeing this? I know you travel a fair amount, not just in this 50th anniversary year, but pretty constantly. Are you seeing this all over the country?
Yes, there are so many things going on all over the country, whether it's in Kansas, small towns, the journalism programs, figuring out how to deal with racism, racist incidents that have happened in their schools. I was just talking to some students there. Students in Minnesota are standing and speaking up about the climate. It's a girl in Arizona who wanted to wear a Black Lives Matter shirt to school. And the School Boards Association there worked with the principal who had tried to stop her. And the lawyers, encouraged the principal to learn about the rights of students, and so she was able to wear her shirt to school in the end. But I spent a lot of time now talking also to administrators and school boards and school board lawyers organizations, and I find that so many lawyers for school boards are, interested in wanting to encourage kids to use their rights in ways that are, responsible and that are within the law.
What do you think lawyers can do? What's the role of lawyers in the fight over student rights?
I meet so many lawyers like you, Steve, who have spent a lot of time and a lot of their lives, encouraging young people and going into the schools or other venues to teach students basic civics, number one, to teach them the First Amendment, and to teach them how they can use their rights, also responsibly. There is that issue to get involved, to testify at the city council, testify, at the state legislature. Students in Florida, they went to the state legislature immediately after the 17 students were shot and killed their last year. So lawyers can go into the schools, and I meet many who do, and they can also, learn about youth issues. Someone told me many years ago, whatever each of us does in our lives, we should also do something to promote young people's well-being. And I think all of us can follow that advice. But lawyers can also go to tinkertourusa.org right now and see all of the events that we have in the works for celebrating the 50th anniversary of the Tinker ruling, which is coming up late February.
So I promised Mary Beth we would let her have that one commercial message. Tinkertour.org is the website that she's created to mark various events for the 50th anniversary. So let me just give a little bit of background, and then we're going to jump into questions for the panel. You heard her talk about her experience and what led to the Tinker case. The Supreme Court decided Tinker versus Des Moines Independent School District on February 24th, 1969. So the 50th anniversary is a few weeks from now. It was a 7-2 decision written by Justice Abe Fortas. And just 4 quotes I will read you from the decision. I guess the most famous one that gets cited all the time and used all the time is, "It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate." That's usually reduced to students don't lose their rights at the schoolhouse gate. One of my other favorites, a couple of other favorites, undifferentiated fear or apprehension of disturbance is not enough to overcome the right to freedom of expression. And another one that talks about the image of students, because I always want to remind myself that Tinker is not just about this narrow, can you wear an armband to school issue. The opinion actually has a much broader vision of students and rights and education. So one of my other favorites, students may not be regarded as closed circuit recipients of only that which the state chooses to communicate. And if you think about that, it's kind of a beautiful image. The flip side of the quotes, and I would be remiss in not pointing it out, is the legal standard that the court ultimately adopted, which is that materially and substantially interfering with the requirements of appropriate discipline, or in another part of the opinion, with the rights of other students, allows school officials to restrict speech. So that has been reduced to the material and substantial disruption standard. Schools may act if there is a reasonable expectation or threat of material and substantial disruption. Mary Beth in the video mentioned the other three cases, and I'll just mention them quickly, and then we'll jump into it. I often tell my students, I teach at American University Law School in Washington, and I often tell my students that Tinker is one of those rare cases where it enunciates a new right, and in the same moment that it enunciates the new right, it reaches the high point of that right. Because you almost never see Tinker cited by the Supreme Court after Tinker itself when it's not followed by a comma and a but. Students don't shed their rights at the schoolhouse gate, comma, but. And the three decisions I'll mention quickly are the but. Bethel School District versus Frazier in 1986, a 7-2 decision which basically said that schools can restrict speech that they consider to be lewd or vulgar or age inappropriate, being delivered to students who may be offended or bothered by the speech. It gave school officials greater leeway to restrict speech, even if it wasn't necessarily clear that it was materially and substantially disrupting, and it certainly wasn't obscene. The court used the phrase lewd and vulgar. 2 years later in Hazelwood School District versus Kuhlmeyer in 1988, the court upheld the authority of school officials to restrict speech that might be perceived as school-sponsored speech. This was a school newspaper that was part of the journalism class. The legal standard the court adopted there is that if school officials if they have a basis for regulating, it has to be reasonably related to a legitimate pedagogical concern. So if the school officials say, we want to censor this article in the school newspaper, and we have a reasonable relation to a legitimate pedagogical concern, that becomes another exception to Tinker and gives the school officials more leeway to restrict. And then the third one, which I'm not sure anybody really knows what it means, but that didn't stop the Supreme Court. In Morse versus Frederick in 2007, otherwise known as the Bong Hits for Jesus case, a high school student, the Olympic torch was going to pass by the high school in Anchorage, Alaska. The school let the students out to go across the street and watch the torch come by. This student held up a big banner that said Bong Hits for Jesus. I don't know what it means. The student says he doesn't know what it means. Chief Justice Roberts seems to have figured out that whatever it meant, it was some form of advocacy of illegal drugs, and that was good enough to allow the school district to prohibit the speech, especially because the court said it was a school-sponsored event, even though the school had dismissed the students for the day so that they could go out to watch the torch. But there were teachers and school officials there with them, so maybe a close call. Those are the three subsequent Tinker cases, but each one in its own way, cutting back on Tinker in some significant way. That's the framework we're working with, and I'm going to turn to our guests and ask the first question, which is really just what Mary Beth was talking about. What does the Tinker decision mean to us today? Anybody jump in?
Sure. My perspective is really born out of 43 years of representing school districts. And I would say to you that I would take a little bit of exception with what Steve just said, because I think in the real world in which I live, school boards, school administrators, school lawyers respect Tinker as a broad proposition favoring the rights of students to exercise free speech. It's not without limitation, but I would say that when you look at the three cases you mentioned, which I think generally are recognized as perhaps retreats from Tinker. I don't view them that way really at all. You look at Frazier, lewd speech. Well, whether it was lewd or not, I mean, his sophomoric speech as he himself described it, but it's not the kind of gloss on Tinker that finds its way into very many school decisions that are brought to our attention as lawyers representing a very large number of school districts varying in size from 150 to 30,000 students. So Morse is out there, and it does, in one way, limit the right of a student to speak if that speech is deemed to be lewd. That tends not to very substantially circumscribe the rights that students actually exercise. And I would certainly agree that, Morse and whatever the word bong hits for Jesus means, if it stands for the proposition that you can't advocate illegal activity, okay, but I think, Stephen, you and I were talking about this before the panel began to make this address. I can't think of another case where a court has said, well, we're going to prohibit this other type of speech because it advocates illegal conduct. And Kuhlmeyer is an interesting case because if you take a look around the country, I think you'll find that states, and I don't think Iowa is typically viewed as a tremendously liberal state, but we are capable of rendering certain progressive ideas, and one of them was after the decision was handed down in Kuhlmeyer, the state legislature decided that that was not how we were going to run our schools. So as a matter of law, by state statute, students have much broader protection to exercise rights with regard to publications. And the school administrators are fairly carefully circumscribed in what it is they can do to restrict that exercise. Iowa is not alone in adopting that particular reaction to Kuhlmeyer. But for me, the bottom line is that when we teach our administrators, when we teach other lawyers about student-free speech, we start with, and perhaps almost end with, Tinker, with the notion that it embodies a fairly simple concept. And might sound simplistic, but I'd like to tell people that if you're thinking about expressive conduct on the part of a student, whether that's something verbal or a gesture or something written, there ought to be a Tinker bell that goes off in your mind if you're the administrator. Something that says, wait a second, can I pause for a moment and consider whether or not this young woman or young man is exercising a right that I have to recognize and respect. And I think to a large extent we've been successful in doing that. So I think the vitality of Tinker remains very significant. I would say that it informs my practice and has for 43 years. And it does it in a positive way with a genuine respect for the right that students have. I'm not saying it's without conflict or controversy, because there are controversial subjects which then become the subject of the exercise of this right. But that's a separate matter. So as to the law itself, I almost think of Morse and Frazier and Kuhlmeyer as footnotes that really do not dramatically impair the basic right fairly generally recognized by lawyers and administrators.
All right. In terms of Tinker today, thank you. In terms of the relevance of Tinker today, as the old saying goes, may you live in interesting times. We live in interesting times in terms of First Amendment in educational areas, be it K through 12 or university. Traditionally, when we think of free speech in an educational setting, we think of the conflict as being between administration and students, sort of the traditional Tinker setup. But what we're seeing more today, kind of interesting, is actually fewer students, or I should say more students requesting suppressing free speech or requesting the suppression of unpopular ideas on the university campus. Students, are speaking up more. As Ms. Tinker mentioned the idea of Black Lives Matter or Parkland. Students are very engaged in advocacy of their own beliefs, but they also seem less supportive overall of speech with which they disagree. Just some kind of quick statistics coming out here. In a recent survey conducted by a center at Yale, while about 60% of students acknowledge that hate speech, whatever that term means, is protected by the First Amendment, 62% supported the idea of hate speech being censored on social media. Over 60% supported the idea of universities banning speakers who have a history of hate speech on their campus. 33% thought that sometimes physical violence was justified in order to suppress hate speech, and a plurality of students endorsed the idea of the heckler's veto, being able to shout down or disrupt a speaker with whom they disagree. Even less sanguine was a recent Brookings survey where 39% of students thought that hate speech was protected by the First Amendment. 44% didn't think so. 51% again thought that using the heckler's veto against a controversial speaker or a speaker who can say harmful things is justified. 62% thought that legally speaking, if a group that had hurtful or harmful ideas came to campus, they were legally required to have a speaker to provide a counterbalance or a counterpoint to that harmful message. And 53% of students said they preferred an educational setting where they would be shielded from harmful ideas rather than a campus where they would be exposed to a full panoply of ideas, including those that might be offensive or disparaging. So in terms of the future of Tinker, where we're going with the Tinker rulings, it's interesting to think of the idea that the future generations coming forward, the future leaders coming forward, future educators coming forward, are ones who have, perhaps, less than robust belief in full range of freedom of speech protections. You know, the kind of traditional 1960s viewpoint here of students are the ones advocating for shocking ideas, controversial ideas, seems to be backpedaling. That the Voltaire, I may disagree with you, say, but fight for your death to say it, that does not seem to be a popular view with college students today. So in terms of where is Tinker going today, looking at where our students are, I'm a little concerned.
So I would take a different tact and view Tinker in light of having given rise to a significant wave of student voice and student activism. And so I'm a school board member, but have also led a nonprofit that has worked with young people, have been in the classroom, done education policy, and I've just seen the arc of young people really in this moment coming to the forefront. I think that's partly because of Tinker and what it has provided for students. And so Mary Beth Tinker spoke about the various movements that have been at the forefront of our understanding the past few years, so Black Lives Matter and other movements. But I would say when you look at, say, Parkland, when you look at the recent UTLA strike in LAUSD that thankfully just ended a couple of days ago, when you look at gun violence, when you look at the issue of same-sex bathrooms, young people have, in a variety of ways, whether it's through student walkouts, whether it's through simple nonviolent acts of protest, have really leveraged their ability to express their rights in the schoolhouse in order to move movements forward, in order to lift youth voice. And that youth voice has been accepted in many spaces, whether it's by administrators, whether it's by teachers who have partnered with young people, whether it's by community. And so I think Tinker needs to be viewed in a variety of different ways, obviously, but I think one way that it ought to be viewed is the rise that it's given the fire that it's given to young people and their ability to lift their voice and discuss and to petition and to argue and to fight for things that they believe in.
All right, thank you all. One of the I don't know whether it's hot because it's recurring or recurring because it's hot, but one of the hot issues that is recurring and that the Supreme Court seems to be going out of its way to avoid deciding is the reach of school authority to regulate communication over social media by students. The cases take a broad range of facts and circumstances, but typically we're talking about student speech on a social media page, on Twitter, on Facebook, wherever it is, often posted from home, but about something at school or someone at school or a classmate. Sometimes it causes controversy at school, sometimes it doesn't. There are cases in almost every federal appeals circuit on this issue. There have probably been, Jim, a half dozen cert petitions over the last decade.
Yes.
And the Supreme Court has denied cert to all of them. So two things about that. One is, do we need a new standard that will deal with the changing reality of social media? And two is, will the Supreme Court ever get there?
I think it was disappointing to me personally when they ducked the last time with Layshock and JS versus Blue Mountain. Those were prime opportunities for the Supreme Court to weigh in on the subject. I'm sure they had their reasons for not doing it. I'm not sure how helpful those reasons were. It doesn't matter. So we have these competing decisions, Steve, that you have referred to correctly. And exactly where the line is drawn, I don't know. It is curious, if you look back at the series of cases, and there are quite a number of them, you know how dated it is when one of the cases involves a parody profile posted on MySpace. Because the phrase, "that's so MySpace," now tells us that something is ancient. So, I think about the cases, and as a practitioner, they're very problematic, because when an administrator is the subject of a virulent attack that has been prepared and executed completely outside of the school day and off-school grounds, you have to remind that person that in many instances, unless that actually causes some disruption within the school district, they have to tolerate it. And that's a hard thing to do when you are personally attacked in sometimes hideous ways. But that's the nature of speech, like the speech that was protected in Phelps. Okay, so I think the question's a great one, because I don't know, if you read Tinker carefully, and this is something that I haven't always done, but I did again in preparation for today's presentation. Justice Fortas, talked about the speech of students, whether at school or outside of school, being subject to regulation under one of three circumstances. And some of these get conflated, and I think there's a danger in doing that. When I say conflated, what I mean is we have this notion that there's a singular rule announced in Tinker, which is if there's a reasonable forecast of substantial material into substantial disruption, you can regulate the speech. That's not, as I read Tinker, quite what it says. Tinker, I think, says that you can regulate student speech if one of three circumstances exist. If there is material disruption of classwork, that's separate and apart. So that's material disruption of classwork, or the speech involves substantial disorder, not necessarily involving classwork, and the two are not combined, or involves invasion of the rights of others, the most neglected of the three prongs of Tinker. And one, by the way, which becomes critically important when you think about the district's obligation to protect students from bullying and harassment, which exist under Title IX, other federal laws, and innumerable state laws enacted with regard to cyberbullying. And so when I think about this question, I think that the Supreme Court will remain reluctant to weigh in on the subject. I think they'll leave the matter to the courts of appeals, and I think we'll just sort of struggle our way through this. And by the time we get a decision, it will likely involve some technology which is only 20 years out of date, which will be wonderfully helpful to all of us who actually try to counsel our clients and give them good advice. But it's really tough, because the fact of the matter is this is a nuanced analysis that is different for every single case. You can announce a broad principle which will be universally recognized as applicable to the speech of students when you think about the incredible, infinite, varied ways that students can choose to express themselves. So we're going to be left adrift and hope that we can find some guidance, the basic principles of Tinker. Okay, how does this impact the operation of the school? And if we can't find a connection that's legitimate, we ought not to regulate it.
I actually agree in many respects with what you said. So social media is not going anywhere. After I finish, I'm going to tweet this out. I may put something on Instagram. Don't have Snapchat, I may put something on Facebook, right? And every time I open one of those apps, there's a new series. At Facebook, 7.5, and Instagram, has another upgrade. And students are doing that on a regular basis with more frequency than I am. The point where I think we have to be thoughtful about how we look at social media and its impact is on the issue of cyberbullying. And is on how that plays itself into both in school and out of school. And so we've seen instances of young people engaging in bullying young people committing suicide, fights being filmed, and then that spreads throughout the school. That's problematic, and it creates an environment that has less tolerance, that results in all sorts of challenges. I think we have to be thoughtful about how we regulate that. I think part of that comes from how we engage with young people on campus, how we talk about civility, how we talk about tolerance, what degree school discipline plays into that. But I think our lesson has to be, and my belief is that more adaptation, so we need to adapt to an evolving sort of usage of social media rather than more constriction of student speech through social media. So less regulation is what I would say is most important. And I think, again, we need to just continue to insert the principles of respect and civility in the common discourse, in the manner in which students are taught on campus. I think that will lead to less of those types of incidents. But the issue of cyberbullying as it relates to social media is one that I think confounds a lot of folks, a lot of school districts, a lot of school board members, this one including. And I think we just have to continue to talk and find a pathway to stop it.
It's funny, you mentioned the idea of sort of less regulation and basically trusting the students to do the right thing, because I think that there's actually an instructive example over that bore itself out, and that's with the perhaps thankfully now defunct app called Yik Yak, which was quite the issue on college campuses and high school campuses a few years back. For those of you who don't know, Yik Yak was essentially an anonymous message board type app, which was based on location. So if you're at a college campus, you'd open your Yik Yak app, and you'd see lists of the various postings that were made completely anonymously on that college campus. Or if you were in a high school, more troubling, you'd see the various postings that were made anonymously at that high school. So it was location-based and completely anonymous, which led it, perhaps not surprisingly, to being a bit of a pit. There were many complaints by faculty members and by students about basically disgusting, harassing sort of things being posted on it about students, about teachers, about administrators, about a panoply of individuals. And essentially, what happened was, there were complaints with Yik Yak. Colleges tried making it so that Yik Yak would not be supported on their Wi-Fi networks, but students could then just go on their roaming data and utilize it in that way. High schools and junior highs were able to successfully lobby Yik Yak to simply not have it available on those settings. If you're within a certain number of feet of a high school or a certain number of feet of a junior high school, the application would not work. But ultimately, what really killed Yik Yak, again, perhaps thankfully so, is, like the song says, the kids are all right. Students basically recognized that it just became this center of backbiting, disgusting speech, and about as quickly as it gained popularity, it died. The app launched in 2013. In 2014, you had a great deal of controversy about it. 2015. By 2016, the company was defunct. They couldn't find a seller. They closed the application. It's no longer supported if you try to open it. And what happened wasn't killed through regulation, wasn't killed through litigation, wasn't killed through the courts. It was killed through students basically deciding to do the right thing. It was killed through the markets and the absence of regulation. And I think that's instructive. I think the idea of trusting students sometimes to get the idea that, civility matters, that they don't want to wallow in a pit. They want to actually speak on intelligent matters. They want to avoid hostility. And that's what bore out. And the Yik Yak model, kind of based on anonymous slander, proved to be not profitable. And I think that's a terrific example going forward.
I would just want to know where they got the name Yik Yak. That in of itself seems like it would have killed it from the jump, but I digress.
And I'll just add to Jim's comments. I mean, to me, there's a two-part explanation to what the Supreme Court is doing in this area. One, and I think it's probably the real answer, is that they don't have a clue how to answer the question and how to deal with the social media challenges. And I think probably realize that there's some risk that they would make a mess of it if they try. So part two is what they've done is convince themselves that there's actually no conflict in the circuits over these issues because the difference in each case is a factual difference in the application of the Tinker standard rather than an actual conflict of standards. And that allows them to persuade themselves, okay, we don't have to decide this issue. All right. we've talked a little bit about this, but let me ask it in a slightly different way and get some different perspectives. Clearly, I think one of the toughest challenges that the issues we're talking about involve today, or the challenge of administrators and teachers figuring out how to balance the needs for discipline and order in schools against the tinker notion of student rights. So I wonder, where are we in that balance?
Well, I think that it's challenging today as it was then, but the major difference is that there is a broader, I would suggest, much broader acknowledgement on the part of administrators that they can't simply discipline speech or conduct, expressive conduct, because they disagree with it, or because it might offend some one person. The reality is that we talked earlier about the heckler's veto and what that means. Let me give you an example of what it has meant for the Des Moines district. And let me just preface this by saying that my law firm, Ahlers and Cooney, didn't actually represent the school district. Another law firm did, so I'm free to criticize. But notwithstanding that, no, the fact of the matter is we have represented that district for quite a number of years. And within the last year, at Roosevelt High School, the same high school that John Tinker attended, a young lady came to school and she was wearing a t-shirt that was a pro-life t-shirt with a picture of a fetus. That offended one student in her classroom. That one student went to the teacher, who then went to the principal. The principal then summoned the student to his office and said, you know, you're going to have to cover that up. And so she did, but she went home and talked to her mother. And then she and her mother came back to speak to the principal and explained that they believed, well, I should say there was an intervening moment, because after this happened, the principal then finally heard the Tinkerbell and called for legal guidance, and we explained that he had gone too far, that there was no real disruption in the classroom, and that as a consequence, his suppression of her free speech was violative of her rights. So mother and daughter come in, and they're talking about how this is very upsetting to them. At the end of the day, in this conversation, principal apologizes, mother and daughter and child and principal all hugging and just feeling much better about themselves. Well, to me, it's instructive of what can happen when there is a potential conflict between the right of the student to exercise her right to free speech and the imposition of discipline. I'm not suggesting they all turn out this way. If they would, we wouldn't need lawyers, and that would be a bad thing. We would not have all the work we have to do. But seriously, I like that example because I believe it suggests that there is a way for us to deal with issues that don't necessarily have to end up in court. I mean, as a lawyer, my approach has been for all of my years to avoid having a client in court, even though clearly you can make a lot more money doing that. I have prided myself on trying to resolve problems at the lowest level always, even if that means sometimes you swallow your pride and you make a decision or you give advice that clients don't like to hear. If we only give clients advice they like to hear, then we can be assured that we'll have a lot more litigation. But that's not our role and ought not to be our role. So this is a tough question, what you do when you're trying to administer the First Amendment and you end up with conflict within the schools. But it doesn't always have to end up in court just because it ends up in a conversation that might be unpleasant.
It's interesting you mentioned, though, at the kind of K through 12 level that we're seeing greater respect for speech on campus, because even though many speech regulations, whether they're free speech zones, whether they are academic freedom issues or speech in the classroom issues, generally don't survive First Amendment scrutiny. Nonetheless, we're seeing a continued increase in the number of speech regulations being promulgated by administrators at the university level. It's almost Hydra-like. It seems like that as soon as one gets successfully challenged in court, struck down on First Amendment issues, you're already getting a numerous similar regulations appearing on campuses and having to be challenged piecemeal. So it's an unusual situation that, generally litigation sort of deters, the promulgation of these sort of administrative rules. The fear of being challenged in court might cause a university or an entity to cease a particular type of behavior. Yet the university level, this isn't so. And now the interesting part might be, why is it so? Is it because of a thought of student demand? So the idea that, well, students are our consumers. We want to give our consumers a product they find desirable. That product is one where a university has speech restrictions. Is it because of fear of Title IX challenges? The why might be an interesting tangle to get into, but we're not seeing that same sort of Tinkerbell effect at the university level, despite, again, the pretty much successive string of defeats of these promulgations at the federal level.
I would just add to it that, the toughest challenge that I see is overreach and overreacting with teachers and administrators, particularly at the K-12 level. But I think the question sort of opens up a conversation about the broader issues of the intersection between free speech and school discipline, school safety, particularly when you think about what that means for teacher training, what that means for culturally competent educators, what that means for how teachers are de-escalating a situation so that they don't turn into litigation, or that they don't turn into headline stories on the nightly news, which you've seen those instances on two extremes, right, where teachers are engaging. There's an incident in LA or in LA County where a teacher got into a fight with a student approached the teacher, and both the teacher is in court, and the student had discipline rendered as well. And then you have other instances where students are just simply trying to exercise their First Amendment rights. So I think it opens up a broader set of questions. That's a conversation for another panel, but I think those are questions ripe for discussion at some point.
Additional thoughts?
Actually, I do. I was fascinated by Sam's commentary, and he made earlier observations that I have shared as well. And it's odd. I went through college in the 60s. I am a child of the 60s, and was involved in various protests myself. I remember Kent State marching that chant. And to think that in the evolution of really a relatively short number of years, you would have people intolerant now because someone chooses to have a point of view different than their own is remarkable and disturbing. I think the notion ought to be that at the university level in particular, where we believe the people engaged in a discussion are more mature, that the invitation to a robust debate is welcomed as opposed to something which ought to be shunned. And we ought to be sure that people are sheltered so they don't ever hear anything that disagrees with their point of view. How do you advance anything in your life if all you do is listen to yourself and ask yourself whether you agree with yourself? I don't think that works very well. And I think if that is a prevalent attitude, and I know what we're suggesting, that you draw a line and you wait for it to be litigated and then you retreat from that line, and that's just a wonderful way to administer any policy. But it is very disturbing when at the level of the university, to just think back to the Middle Ages and the evolution and creation of the universities and the whole idea behind education at that level and what it's supposed to foster, and ask yourself whether or not we have really devolved from that point so that we now become a place where you can speak only as long as there isn't someone who doesn't happen to disagree with your point of view. Not a good place to be.
So one of the things that I've always loved about reading the Tinker decision, and a couple of the quotes that I read from it, is I view those parts of the Tinker decision as being a kind of wonderfully uplifting, almost Renaissance vision of what students and education ought to be about. And I wonder if we've lost sight of that, the Tinker part that is encouraging students to think for themselves and speak their ideas as they think them. Is that, are we still there?
Look, I would address that by citing a quote that Dr. King wrote while a student at my alma mater, Morehouse College, that the function of education is to cause one to think intensively and critically. schools are and should be at that age embryos of the marketplace of ideas, the embryonic stage of marketplace of just a broad base of ideas. I think that obviously wasn't, the belief in Hazelwood, where, they were regulating the commentary in a paper about teen pregnancy and divorce. But that's what a school ought to be, and on both sides, right? And it should be healthy respect for debate and dialogue. And I think we see that in many instances where young people are talking about the issues that are most germane to them, right? So young people that I'm working with are talking about issues of gun violence that is impacting them on campus, talking about issues of how they are traversing the school and the challenges with gang violence and the like. They're talking about trauma, they're talking about suicide, talking about just the broad mental health pieces. And they're having those debates, they're talking about politics on campus. A school campus should not be the place where we are censoring the ideas of young people. There is a movement in California of young people. So I work for a private foundation that gives out a lot of money, and the foundations, a lot of foundations in California are focusing their philanthropy on how they continue to lift up the voice of young people who are powering political movements, who are inspiring elected officials and others to act. That's germinating in a school environment, and I think it's just so important. I will say this and then yield. One of the things, so I've met, I still call him Professor Vermeil, at law school some time ago. He was professor, con law professor, but also most importantly, Marshall Brennan Constitutional Law project professor, where students at American University would go and teach in DC public schools and teach on cases like Tinker, but teach broader con law, criminal law, and other subjects to DC school students. And in that moment, and that was a while ago, I won't date myself, it was a while ago, you saw the ideas of young people sort of surfacing. I mean, when we taught these cases in DC schools, they were just thinking, how could they change their city? How could they change their neighborhoods? How could they change their circumstances? They were having those debates on campus. So I think it's absolutely important that we allow schools to be a place where ideas are fostered, debate is encouraged, and young people have a springboard to doing that post-graduation when they go on to their path on college or career.
I would offer 4 observations about whether there's a retreat, Parkland, illegal immigration, transgender bathroom rights, and the pro-life. I think if you look at what happens in K-12, and we represent colleges as well as K-12 institutions, but the vast majority of the clients we have obviously are K-12 level. If we're thinking about whether or not Tinker still has vitality, and we're thinking about whether or not that vitality is not just theoretical, but real, think about what happened after Parkland. If you're aware of what happened, then you know that throughout the entire country, not limited to Florida, where I think ironically there was criticism and pushback against students for having the audacity to suggest that they have the right to talk to their legislators about what needs to be done to protect them. Okay, set that aside for a moment. In a relatively spontaneous way throughout the country, there were walkouts that were generated by students wanting to focus attention by way of sympathy, but also by further extension because of opposition to gun violence. And almost without exception, those walkouts went on without incident. And I don't suggest by that they had no impact. I mean, the students organized themselves. They said, we're going to walk out. And most of our clients, if not all of them, when they counseled with us, followed our advice was let the students walk out. I mean, regulate the conduct if they choose not to come back, because at that point they'd be truant. But if they want to walk out and they want to stand around the flagpole and they want to protest gun violence, let them do that. And when you think about the other topics, transgender bathroom rights, those have become very controversial, but students have organized to speak about that. They've organized to speak about illegal immigration. So, I mean, there are a number of topics, and again, this is at the K-12 level. I'm not suggesting this doesn't happen at the college level as well. But in that crucible of public debate, students have been willing to exercise their rights and do so in a way that I think that has favorably garnered significant public attention. And you know, whether it motivates people, it's difficult to tell, because the people you're hoping to motivate many times are people highly resistant to changing their position. The laws of physics are immutably applicable to human behavior. A body at rest tends to stay at rest, and the force necessary to overcome the body at rest is enormous. The body at rest is the body politic in the form of the legislature. No one should be naive enough to believe that one day, whether it's a day of silence or a day of when you walk out to be at the flagpole to protest student deaths at the hand of gun violence, that will be sufficient. It's not. But that's not to say that it isn't significant, and it's not to say that it doesn't carry with it an important message, because those are voters and those are future legislators.
Jim, can I ask you a question about that? And I think if I ask it quantitatively, there's no attorney-client privilege problem.
Okay.
Take your 150 school boards.
Yes.
If you hadn't been giving them the advice to go with it, manage it, but let it happen, how many of the 150 school boards as a first impression would have said, we can't allow this?
Well, it wouldn't have been, I don't think, a majority, but it wouldn't have been an insignificant minority either. So, but you know, part of what we do, if we're lawyers doing my kind of work, is we don't educate just superintendents and principals. We try to educate school boards, and that means being willing to give them advice that they don't like to hear, and to do that at the risk of losing our jobs, which is just part of the business.
Funny mentioning the kind of really organic parkland inspired walkouts. It got me thinking a touch, something that we actually mentioned earlier, something which article by Zenas and Moy once said was sent by neither God nor the devil, and I'm talking about social media. And you know, social media gets, particularly in terms of speech issues with students we were discussing before, it's scary. We don't know if we want the Supreme Court getting involved. We don't know the sort of speech that can get spread on social media, what students are saying in their own time about fellow students. But for social media, you probably don't see these engaged, active students. I think that the idea that there's a nationwide walkout to protest gun violence, that doesn't happen if students are, you know, using smoke signals or tin cans held together with twine. That happens because we have social media use, and we have social media savvy students. So for all the negative attention things like Twitter can come in for, and much of it deserved, and I've said enough about myself, about the negative effects of Twitter, but for social media, we kind of don't see this, I think, renaissance of student activism. And I think it's something that does bear consideration when we think about what sort of conduct should or shouldn't be overseen by students online.
I've got two more questions, and then I'm just announcing that we're coming to you all. So I hope you're thinking of questions and are ready to jump in a couple of minutes. I want to actually combine two ideas. One that Mary Beth talks about in the video, and then a question that Jim had asked me to raise and has already mentioned. One thought is, since we're talking to a room full of lawyers interested in this subject, so one thought is, what can lawyers do with regard to student rights in their communities? But an aspect of that Jim had very thoughtfully raised is, probably we would all agree that when we're talking about an individual case of fighting over one student's speech, having that resolved in federal district court is not the most efficient way to do that. So I might combine those two thoughts. What can lawyers do in their communities? And as part of that, are there alternatives to these cases ending up in full-blown litigation that might be more productive?
I think the lawyers on multiple sides of the issue have responsibilities. I'd like to think that not just the lawyers in our firm, but other lawyers who practice educational law on the school district side of things, take an approach similar to the ones that, and when I say we are problem solvers, I don't mean that I personally am the only person in my firm. We have about 40 attorneys, and we represent, as I said, these large number of districts. I think without exception, all of the people who are in our education group take the approach that we want to avoid litigation and encourage problem solving. Okay, so on the one hand, you want that to happen in a way that's respectful of the need to maintain order as long as you can do that. And to avoid litigation. But this doesn't really work at all, frankly, if you have somebody who has a plaintiff's lawyer's mentality, mindset, and that's not a denigration of them, but if you come thinking, well, I've got a great 1983 action, and I'm going to make an example of this district, and we're going to get attorney's fees, and okay, that's fine. I mean, you may, in fact, believe that that is the best way to vindicate the rights of your client. I can't say you're wrong. But I can suggest that there's another way to address it that will not generate very much by way of fees, but which ought to be viewed in a more, in a broader way, is much more satisfying. If you can get a school district to recognize that it has crossed a line and is willing to back up from that line, if you work with a client and you know what I'm talking about, and they have to say, it's like, for those of you in the room old enough to remember Happy Days, there was a character, well known, Fonzie, who could never say it was wrong, okay? He just couldn't get the word out because Fonzie was never wrong. Well, the clients are a lot that way. They don't like to acknowledge they're wrong. And you know, if you have particularly administrators who come from a mindset that, by the way, I'm in control of this place, in case you were wondering, and people are going to do what I tell them to do, that's difficult. It doesn't, the job that we have on one side of the issue doesn't become any easier when the people on the other side of the issue decide that there isn't any answer other than for you to acknowledge and pay money to make this go away. So what can lawyers do? It seems to me that one thing lawyers can do is mutually engage in problem solving with an understanding that that produces a better result, almost always, a better result that will have much more favorable consequences on both sides. You know, if you're the student and your rights have been infringed, and you actually hear, as one student did in Des Moines, a principal say, I'm sorry, it's a big deal.
Completely agree. I think problem solving has to be the order of the day. It's a mutual act between administrators, between the teachers, between the students, their parents, and community members who may get engaged for a variety of reasons. And I think when I look, knock on wood, we don't have any active litigation of consequence in our county district right now. That we are not, have not really, that we have not addressed through some sort of mediated problem solving. And we have a superintendent who's committed to that. We have a general counsel in her office who's committed to that. And I think when I look at the range of sort of issues that have garnered some media attention, particularly in my county, it has been resolved through dialogue and just rational folks coming to the table. Obviously, folks have an interest in making students the priority and not getting their interest in the way. And so folks coming to the table, having rational dialogue, trying to think through some very critical issues, I think is something that is a lesson for a lot of places, not just the schoolhouse. But it is what I see school districts doing more and more to try and avoid litigation.
All right, my last question.
Excuse me, before I just one final comment. I commented about the role of attorneys on the other side. I don't have any problem whatsoever with plaintiff's attorneys taking the matter to litigation if you have recalcitrant clients that we represent. If you've got people who simply dig in and say, you know, we're not backing up an inch, we didn't do anything wrong, we're not going to acknowledge we did anything wrong, you end up in a situation which gave rise to Tinker. I mean, let's think about that. That's where it happened. I mean, it certainly had the law firm advised the district, say, you made a mistake, you ought to resolve this case, we wouldn't have the case decided as it was. But my point is there are times, extremely important times for plaintiffs' lawyers to be advocates who don't back down. It's just that if the mindset is always the only way we're going to get resolution that's satisfactory to our client is by way of litigation or an abject kneeling on the ground and prostrating in homage to the person whose rights we offended, that's probably not going to be successful.
But I guess beyond just terms of plaintiffs, lawyers, and defense lawyers, do you do any work, Alex, in your area, or Jim in your area, with local bars and their ability to help educate students on their rights and responsibilities, and going into the schools and teaching responsible free speech or things like that? I mean, Alex, you did that in the Marshall Brennan program, but...
Yeah, there is a practice. It's not as widespread as it ought to be, and I'm glad you brought that up, because that would be a very good way for lawyers to make an impact, to go out and spread the word, if you will, to educate students. Because it's not just a matter of knowing that you have a right, it's knowing that there is a corollary to that right, which is to exercise that right in a respectful way, and to acknowledge that in your exercise of that right, you have an additional obligation, which I think, think about this for just a moment. We have compulsory education in every state of the country, right? And we know after Barnett you can't have a compulsory speech. What we do have is compulsory listening. Something I really hadn't thought very much about until I was invited to participate in the panel. What do I mean? I mean, let's suppose you're in a classroom and you happen to be a pro-life person, and the person who sits immediately in front of you every single day is a pro-choice person, and they wear a T-shirt every single day espousing a pro-choice message in a legitimate way, protected by the First Amendment. You're there as a sort of captive in that audience, and you have to look at that every single day. Now, that doesn't mean that the person who's pro-choice has violated your rights. All I'm suggesting is that, you know, this exercise that we have, thing called speech, involves an interaction. And when you talk about going out to teach, and that was wonderful what you were able to do when you were in law school, I'm just hopeful that when we do what we can to encourage the understanding and the exercise of the right, that it's not just with the thought in mind that there ought to be respect, but there ought to be, if we're really sincere about this, an appreciation for listening. Listening is not a passive skill. My wife has pointed this out to me numerous times, and she has been right, she's not here, virtually every time. Okay? And what I mean is that, it's like Stephen Covey, the author, said, most people listen with the intent to respond, not with the intent to understand. I try to remember that because I don't always do this well. But if you're talking to students, then the corollary to the right to speak is the right to listen. Because think about speech for just a moment. If you speak and there's literally no one who hears you, that's protected. If you write like Franz Kafka did and no one reads it, they were all supposed to be destroyed, as you know. All of his writings were in German. There's a phrase, writing for the drawer. He literally wrote everything he ever wrote, put it in a drawer, and gave orders that it all be destroyed. So, you know, Franz Kafka's writings could all have been destroyed had his wishes been observed. But that would have been an exercise of speech on his part. Would it have been communication? Is a gesture not observed by anyone speech? Yes, it is a communication. I don't think so. Because the communication we're talking about involves an interaction, which then means someone reacts to what you're saying. So as we teach students about the right to speak, I think we then have to also encourage them that even though there is no constitutionally enshrined right or obligation to listen, that if they're sincere about wanting to speak, they should be sincere about wanting to listen.
I mean, one model for this, which currently has its home in the Civil Rights and Social Justice section, but was founded as a project of the Young Lawyers Division of the ABA, is a project called Bully Proof, which involves young lawyers, when they can, where they are, going into school districts and educating about what bullying is, what can be done about it, what's the law, what should the attitudes be, And that, that's the kind of thing that I think we could have lawyers do more of. I'm going to skip my last question because I want to make sure we have lots of time for you to ask questions. So please have at it. Yeah.
I'm Victor Flores, and I'm the TYLA president-elect coming in, and also part of the State Bar and Texas Government Law section. So kind of know a lot, experienced a lot of what you're talking about. A lot of talk has been addressed towards educating students and administrators and teachers. But even Tinker's interview, and as Mr. Johnson, Mr. Gaines mentioned in some of your cases, is that there are the parents. It seems that the parents are being missed on the educational components of what their students are allowed to do. My question is, in your experience, are there any resources out there? Is this being addressed? And if so, and if not, then what can we as attorneys do to kind of help fill that pocket?
You've asked a very good question, and my answer to your question is virtually nothing. I think when you think about the educational outreach, I was familiar with Bully Proof. I think it's a great idea. I've worked with YLD and made a presentation on bullying with them. I think that's a wonderful thing, but the focus, Steve, as I understand it, at least as it was explained to me by YLD folks, was to get out and make contact with students, as opposed to the parents who are in a different audience.
Right.
And so there's a real challenge. How do you reach that audience? I'm not saying it can't be done, but I'm really not aware of many broad-scale efforts to go beyond teaching administrators and board members and students to expand that to parents.
Right, and something else I didn't mention, I just remember now, is because the disruptive portion of the Tinker test, and whereas the disruption may not be in the classroom, but may be outside of the community, and that's where you have the dynamic of education, government, and politics, and maybe instances where administrators have to deal with disruption, not inside the classroom, but outside of in the community.
Oh, Alex, go ahead.
The issue of parents sort of understanding their students' rights and their rights as parents is woefully undervalued, I think, across districts. I mean, there are community-based organizations that I know of that do that, and that's part of their work. But in terms of sort of a broad national organization that's working with parents, it's sort of intentionally on that issue, fleeting to find one.
Purely,
Oh, go ahead.
I would say purely in terms of the idea of disruption outside the classroom, there was an Eighth Circuit case actually involving a nursing school called Keefe, wherein a student was posting what was seen as harassing or defamatory comments on their Facebook wall, their own Facebook wall, and the school was found to be within their rights to expel the student. So there is this idea that even at that high level, even a professional training program, that causing disruption to, I guess, the educational component of a university or college, while you're not on campus, nonetheless can be seen as being regulated. Now, there are all the other circuits aren't necessarily in agreement with this, and it's again one of those issues where the Supreme Court hopefully would get involved, but hopefully not by the time we're no longer using laptops or the internet or what have you, and we can move on to the next technology. But this is something that, in theory, is ripe for Supreme Court involvement, because we've got split circuits on the issue.
There was at one time an organization that had a fair amount of impact on parents, and that was the PTA. And I don't know, their parent-teacher organizations, parent-teacher association. I grew up at a time when that meant something. But I'm ancient, so I don't know that really exists in the way that it did decades ago. But when you think about how you could find a vehicle to communicate in response to your question, sir, about two parents, that would have been it. That would, at least an opportunity to communicate to parents. And some of the cases, if you read enough of the cases, you are left with the thought in mind that we have some parents who are not just interested in protecting their students, but they're interested in advancing a fight. And that doesn't mean they're wrong, but you do sometimes wonder how cases involving something that might be as bizarre as bong hits for Jesus end up in the United States Supreme Court.
Sir.
I practice law at a firm based in Virginia Beach, and I've had a load of experience appearing in front of the hearing officers, and then you can deal from there to the panel of the school board. From there, if you can show that there's been an obvious violation of law, constitutional right, arbitrary, capricious behavior, you might get court with it, but the judge is very reluctant to get involved and reverse what the school board is doing. And so here's been my experience, and I'm curious to see how many other people are dealing with this. The first thing is that there's a lot of social media that has no immediate contact with the school. They're not using school technology. It's not on school time. It simply is something was said, may or may not have even been about a student or administrator or teacher, that then gets talked about in the school, and then the school says, aha, we have jurisdiction because it created a disruption, which I call doing your job. That's called teaching. When controversial things happen out there in the world, teach. But no, they punish. And then I find myself arguing constitutional principles to people who have no law degree and no judicial training or qualifications. So if you're charged with littering, you go see a real judge in a courtroom where the worst thing that could happen is a fine. But if you've got a child who is facing a negative impact on a constitutional right to a free public education, I'm arguing in front of people who really don't know what they're doing on that topic. I think it's incredibly frustrating. And I think it calls out for major reform. We've got to educate the teachers, administrators, and school board members that not every discussion in the school building equals a substantial disruption, simply because you have to talk about it. And secondly, I think the whole idea that school board members acting as judges is patently absurd. They're not trained for it. Yeah. They're trained to create policy, not act like judges. And unfortunately, that's the system we have, and I think it's horrible.
As I'm sure you know, the Tinker decision itself says the mere fact that administrators and teachers might find it more convenient to avoid the embarrassment or difficulty of dealing with whatever it is not enough to justify regulating the speech.
And I've won that argument, and then the next time I'm in front of the school board, it's in one ear and out the other. They're basically daring me to eventually turn it into a Section 1983 case instead of a straight-up appeal of discipline.
Yeah.
And what do? We need reform, in my opinion. At least we do in Virginia.
Well, then I would say that it's even worse that the Supreme Court was afraid, and I think Steve's analysis of the ducking of the issue may be right on. Will they do something that makes the situation even worse? I don't know. Your experience is dramatically different than the one I have, and my approach, I think, is dramatically different than the one that you're describing. It does call to mind that wonderful quotation, which I looked up from Justice Brandeis only 93 years ago. And I'd like to read it. If there be time to expose through discussion the falsehood and fallacies, to avert evil by the process of education, the remedy to be applied is more speech, not enforced silence. And what you're suggesting is the notion that something occurs in a way and it annoys someone, it bothers someone, they disagree with it, so the reaction is to discipline. I think that's woefully misdirected.
It's oftentimes a student post eventually seen by a parent somewhere. Parent calls school, and then the school feels that it must do something because the parent got involved. That's the loop. It's not usually the students involving the school. It's a parent somewhere who sees a Snapchat or an Instagram post or whatever and then makes it an issue they feel like they've got to deal with. If they get a phone call, they call that a disruption.
Right.
But keep in mind, if you happen to have written a couple books on school bullying, which were generated at a time when cyberbullying was a big issue, if you carefully analyze the statutes that were passed, and at one time, I think there were 49 states, I think Montana finally fell into place and passed a law. But read them carefully, read how they are crafted, ask yourself what recognition, if any, do the legislators provide to the exercise of the First Amendment? And the answer is, and it's a scary answer, virtually none. If you read those cyberbullying statutes across the country, you will find little appreciation for the right of a student to speak in a way that might trouble someone else. And so, look, if you have a death as a result of cyberbullying, it's tragic, it's horrible. It cries out for something to happen, but the something to happen isn't a knee-jerk reaction to say, well, now you can't say anything on social media. That is not the reaction. But read the statutes. And I can tell you, it took me a long time, but I did, and I didn't like what I read.
I just add to that on a very practical level, it just opens up the door to the questions of, the hypervigilance of teachers and how they're trained, hypervigilance of administrators and how they are trained and how they are recruited in the pipeline to that, just on a practical level. Then how school board members, who's on school boards. And so I think that, question of how school board associations are engaging with their school board members, but really, it's the question of who's on school boards and how those folks are elected. I just happen to be an attorney who's worked in education law, who's on a board, who's done education policy. And our board, thankfully, only looks at sort of interdistrict appeals in that particular setting, not and expulsion hearings, et cetera. But some school board members have no idea what it is that they are doing, and so that's just a common piece. I don't know how we solve that other than sort of engaging in different ways in the electoral process and training if they get there.
I can tell you for sure, the National School Boards Association and the Council of School Attorneys, which is a subgroup of attorneys, have uniformly, for many years, taken an approach which is quite different than the one you've described in terms of their education of board members and attorneys. So, I'm not saying it's been successful, obviously not completely successful. Maybe in your experience, not successful at all. But that's not the same as saying that there aren't people who are in a position of responsibility to provide education to school board members and to school attorneys that they haven't been doing their job. They have, but what you're also, I think, sharing with us as a group is that it's like all politics are local. School boards are very significantly creatures of local communities and community mores. Whether that's good or bad, that's what they are.
Any other questions out there? I'll throw out, go ahead, please.
Just one question with respect to the application with the evolution we see of Tinker, with the proliferation of false speech, either intentionally or grossly negligent, and whether that has any bearing.
Sorry, what sort of speech? False speech.
Well, that's an interesting question. I think speakers bear a responsibility to exercise their rights in a way that reflects honesty and integrity. But if you think about Phelps and you read, I personally was involved in a Phelps protest because the Phelps group, the Westboro Baptist Church, came to my community and protested at my church. And the messages they were communicating were extraordinary in their hatefulness, and I would say falsity, okay? Maybe it really just reverts back to what Justice Brandeis said. The answer is not to try to censor Phelps and those of his ilk, but to respond with more speech. I don't know. When you think about that question, do you have the right to say something which is false? Well, if you have the right to say something which in your heart is hateful, why would you not also have the right to say something which to be false? I'm not saying it's the way the world ought to be, but once we have created this thing called the First Amendment, it takes us in places that sometimes that really would rather not go.
Yeah, it's like kind of.
If it impacts an election or something on campus,
Well, I think
does that make any difference?
I'm building off what Jim said earlier about sort of the the knee-jerk response to cyberbullying was to create statutes which effectively squelch a lot of speech, and even speech that perhaps should have been protected, might have a chilling effect. I think the idea of false speech, we already have libel and slander laws. And if you're saying something that's not true, but we can't actually point to a concrete injury, I'm not sure if creating more litigation or more legislation is the appropriate remedy. If the speech is false and it's harming someone, we have civil law available to remedy that situation. And I think that a fear of, whether it's a fear of fake news or a fear of, upsetting people with known lies, I'm very loath to the idea of we need to craft a special type of legislation to do that with just due to the chilling effect that could happen from, what if the person doesn't necessarily know it's true? How do you know it's false? Who's the arbiter of this? It seems to lead us down a path that I think we don't necessarily want to go down when we already have remedies at bar for people knowingly making defamatory comments that cause injury to people.
I mean, the First Amendment law tends to differentiate between false opinion, which the law sort of says there can't be false opinion, and false facts, which can happen. And although the Supreme Court has sort of declined to adopt a hardline rule, the operative rule seems to be if you're alleging harm from falsity, the burden is on you to prove that it involves false facts. It has to be provably false. So if I say, this room is the size of 3 ballrooms, you can prove that it's not the size of 3 ballrooms. If I say, in my opinion, this room feels like it's as big as 3 ballrooms, I pretty much just said the same thing, but you can't recover from me because that was a statement of opinion. I think the interesting question, which we probably all would agree is a tough one, is in a closed community like the size of a high school, the impact of false statements, even if they're opinion, might be more pronounced than in society at large. And I don't know that we really have a mechanism for dealing with that particularly.
Well, add to that Sullivan versus New York Times. And the absence of malice standard. And imagine if you're the target of that, if you're a student and you're the target, well, that's one thing. But if you're the principal or superintendent, forget it. I mean, I've had numerous administrators come to me feeling like they were vilified. Okay, yeah, you're not going to recover. The bar is far too high for you to reach. You're simply going to have to endure those false statements made about you.
We could take one more question, I think, and the clock's clicking down on us. Anybody?
I have a question for the audience, if we don't have one. I'm going to read 2 quotes and ask you if you think you can figure out who, and it's a famous jurist who made these statements. The first is, a heavy federal constitutional hand on the regulation of student speech by school authorities would make little sense. The contribution that kids can make to the marketplace in ideas and opinions is modest. From 2008 decision of the Federal Court of Appeals. I didn't tell you which one. The second is, the basic structure of American free speech law seems okay. Some of it strikes me as silly, notably granting rights of free speech to school kids. Anyone identify either of those 2 quotes? The second quote came from a 2014 interview of this judge. Thoughts? How does Richard Posner strike you? Would you have thought that those would be quotes? So I offer those only because as I studied in preparation for this and felt that I knew a few things, I learned how much I didn't know, which is almost always the case when I study something. And when I read those, I thought, I went back and reread them because I thought, I can't be reading this correctly. I mean, the first case, was from Nuxall versus Prairie Indian School District, a fairly well-known case. Involving Day of Silence observed by homosexuals in protection of their interests, followed by a student, the plaintiff, Nuxall, who wanted to have a day of speech in opposition. But anyway, I leave you with that because if we think here in 2019 that there is like a universal opinion all in one direction, even amongst people that we would perhaps identify as defenders of the rights that we were talking about and hold so dear and think of as liberal and progressive, we might want to step back and rethink that just a bit. Might not all be true.
Well, the intellect of Richard Posner is always a good note on which to end, I think. So thank you for that, Jim. Please join me in thanking our panelists.